This is Jonathan and Mary Kay Borsch Family Foundation et al. Versus MD Industries LLC et al. Docket number 22-202CB. And this is the time set for the receiver's motion to have a continued date and time for the show cause hearing, which is indicate for the record that because of Mr. Doherty's disruptive outbursts in the courtroom, we are conducting this hearing on Zoom only. However, it is completely accessible to the public. Mr. Doherty was provided the Zoom room number, and he is in fact here. We are also streaming it to the media room right down the hallway outside the courtroom in case anyone else showed up in the courthouse to view this. And I'm also live streaming on my YouTube channel right now, and that live stream will remain up for anyone to view. And as I indicated, Mr. Doherty is present, Mr. Polderman is present, and Mr. Polderman, this is your motion. Go ahead.
Thank you, Your Honor. Good afternoon, John Polderman, court-appointed receiver. This is my motion and incorporated brief to continue the show cause hearing. As the court has noted, back in April, I believe it was April 4th of this year, the court set a date and time to take up the criminal contempt, or for Mr. Doherty to show cause as to why he should not be held in criminal contempt. However, before the court could take testimony or conduct that hearing, there was an outburst by Mr. Doherty. He was sentenced to incarceration. He's since been released and is here today. However, I am seeking that those hearings be continued. I also cited in my brief the case of In Re Contempt of Murphy, which is a recent decision that I also attached as an exhibit. That if there is a summary criminal contempt and incarceration that doesn't meet the test for double jeopardy, and the underlying contempt proceeding can't continue. So I am seeking a date and time for the continuance of that. I understand that it would be remote and over Zoom, but I believe there needs to be a hearing on the emails that were sent to numerous parties, and a decision made on the underlying motion. And obviously, Mr. Doherty is entitled to either represent himself or have counsel and prepare for that hearing. So I'm just seeking a specific date so the parties can prepare accordingly.
All right, thank you. Mr. Doherty?
Yes. First of all, how long have you known Mr. Polderman and Simon PLC, Ms. Dragonchuk?
I'm not here to answer your questions. This is your opportunity to be heard in response to the receiver's motion.
So are you failing to disclose your prior relationship that may affect your ability to rule impartially in the matter here?
If you wish to forfeit your opportunity to respond to the receiver's motion, I can mute you, but otherwise, here's your chance.
No problem. Okay, so first of all, that hearing on 4-4 was designed around my respectful and meeting with Ann Krupp of the title company, of which I personally owned that house. I paid for it out of my personal account. Therefore, my wife is still owed approximately $300,000 based on marital property rights alone. And I have been very disappointed with Mr. Polderman of Simon PLC and the way he just literally makes up stories. I've never even imagined that this could actually go down in a courtroom, Ms. Dragonchuk. And I have said multiple times, I don't know how many false pretenses, false statements, examples of perjury, deceit with intent to harm. I have witnessed firsthand from John Polderman of Simon PLC, who has been illegally connected with the plaintiff's attorney behind the scenes. This has just been a miscarriage of justice, to say the very least. And I am again asking you respectfully, as I was before I was illegally put in jail. Everybody, Mr. Polderman, you hear he's just trying to say outburst. The definition of outburst is similar to a volcanic eruption. And I want everybody to go through and actually see firsthand for my actions and my words, which were respectful and professional. But I was simply asking you once again, Your Honor, which I address you as that out of respect for this courtroom, but I truly do not feel like you are capable or impartial enough to be able to, even remotely consider true justice in this matter. And my case hasn't even been heard. I continue getting silenced and suppressed. I had 2 terrible law firms that did not do much of anything in the way of combating these white collar criminals. Therefore, I've taken this in my own hands, and I have done so respectfully. I've done hundreds of hours of research, and at this point, I know what I'm talking about, and I know what true justice looks like, and I know the opposite of that, which is this very thing here.
All right, thank you. First of all, going back to the hearing that we had, Mr. Doherty was anything but respectful. It was a volcanic eruption of sorts, and it happened the moment that we went on the record, and Mr. Polderman called Mr. Doherty to the stand. I would have wanted to advise Mr. Doherty that he had a right in a criminal contempt proceeding not to incriminate himself, but he screamed on the way up to the stand about not having notice, indicating that he didn't mind testifying. I couldn't get him to sit in a witness stand and be quiet so that I could even advise him that he had a Fifth Amendment right against self-incrimination. Even if he did wish to waive it, I would have wanted to at least tell him that, but he screamed in my face instead and made it impossible to conduct a proceeding or to record a proceeding as we are required to do. That said, I think that the sentence he received was well-deserved. One of the purposes behind a criminal sentence is rehabilitation and making sure that the offender does not reoffend. I am not willing to go back at this time and start this anew with the allegations that were previously brought by the receiver. What I would like to do is go forward in the hope that Mr. Doherty can take part in all the proceedings in a way that's appropriate and allows the court to conduct proceedings. I also would note that there are some procedures in place now so that Mr. Doherty cannot send 10 emails a day to all of court staff, harassing and annoying and frightening them. And instead, he has a dedicated email through which he may communicate any legitimate business that he needs to bring before the court, and that will be always monitored. He also has an order in place that's been in place that he's not to harass various different people or have contact with various different people in this case, and that order remains in effect. So I would like to go forward with those safeguards in place, and that is my ruling, Mr. Doherty. I've made my ruling. And so I'm denying the receiver's motion to set a renewed date and time for the contempt. And Mr. Polderman, could you just do an order that indicates it's denied?
Yes, Your Honor. Thank you.
Okay, thank you. That will end this proceeding.